I would like to talk to you about making an application for bail on behalf of a defendant. What is bail? Whenever a case cannot be concluded on a given day, it has to be adjourned. For example, after a first appearance in court, whilst the case is being made ready for trial, or if a trial runs for longer than one day. When the court adjourns, Section 128 of the Magistrates' Court Act 1980 provides that the magistrates may either remand the defendant on bail or in custody. Bail is the release of a person subject to the duty to surrender at an appointed place and time. It is usually the case that if the prosecutor does not object to bail being granted, with or without conditions, then the court will agree. If the prosecutor applies for the defendant to be remanded in custody, however, the defendant's solicitor will, if instructed to do so, make an application for bail. Presumption of the right to bail. Section 4 of the Bail Act 1976 gives a presumption that defendants have the right to be granted bail pre-conviction, and post-conviction where the case has been adjourned for the court to obtain reports before sentencing the defendant. The only limitations on this right are in relation to very serious offences. Where a defendant is charged with murder, manslaughter, rape, a serious sexual offence, or attempted murder or attempted rape, and also has a previous conviction for one of those offences. Section 25 of the Criminal Justice and Public Order Act 1994 allows bail only to be granted where exceptional circumstances exist. Where a defendant is charged with murder, Sections 114 and 115 of the Coroners and Justice Act 2009 only allow bail to be granted by a Crown Court judge, and then only where the judge considers that there is no significant risk of the defendant committing, whilst on bail, an offence likely to cause physical or mental injury to another.